Hello, Internet. I'm Jackie Fox, and in making YouTube videos, in sorting through all of the things that I see and I hear to try to decide what is important and distinctive enough that it bears repeating, and how to tie many threads between many different things together into one cohesive narrative, there are often stories that are kind of waiting for more pieces or get kind of lost in the shuffle. And this is a tale of one of those stories. And it is essentially, in a lot of ways, just a story about selling vibrators. But it gets a lot more broad than that. It talks about communities and our rights, and, it also gets strangely into trademark law. So you might have heard of this lawsuit that happened when the Wildflower Sex Shop, which sells a, let's say, ambidextrous dildo vibrator called the ENBY, which is suitable for men and women. And they have, according to the one relevant piece of documentation since this court case finalized, is actually the case text when it was published. As far as I can tell, as far as Google can show me within a couple of pages of a pretty specific search result, I mean, it found the case text. This looks like the only reporting that has been done on it. So let me bring you that case and what came of it, and why I happen to be the one telling you about this, why it doesn't seem like anyone else is talking about it, because I have a really interesting and strange involvement in this case. So let's go back to the one story that I can find repeated everywhere, by the way, when I look for this without a time frame. When I look for this again, after including the date that the case notes came out to today, I can find basically no coverage of this. But I remember when this lawsuit started, there was a little bit of a story, and apparently it was pretty much just the daily dive. And the only other person that I saw re-uploading kind of the same story was actually a fake website that my virus shield was like, hey, you shouldn't have clicked on that link, go back. That was basically just kind of copying, I guess, the metadata to make it look like it was this article, which, man, I have never hit the bottom of the barrel in YouTube searches so hard, so fast. But this seems to be the one story, so let me read and kind of summarize. A black and trans-owned sex toy store says that a white sex toy store is trying to shut it down following a trademark dispute over the name ENBY, which is a term sometimes used to describe non-binary people, ENBY. The ENBY store, which started its journey at Shop ENBY on Instagram in September, this article is from 2020, so September of 2020, it looks like this all happened about November of 2020, which means that the case took about a year to work itself out. Anyways, threatened to sue over the use of the word ENBY, which is also the name of their a wildflower vibrator that they use, which was launched in the previous year in 2019. But actually an interesting wrinkle of this, by the way, in reading the case notes, was that in the case notes, they go to point out pretty early on in the judgment that Wildflower had tried repeated times to trademark their ENBY product and were repeatedly denied under the same grounds. And the grounds are that it is not a distinctive trademark. That is because it is meant to describe a large group of people, or kind of an identity or something like that. It is not something that you can profit from. You cannot take someone's identity and trademark it. That is kind of a fundamental concept. I mean, you know what? I'm sure there's a trademark lawyer that could... I wish I had a legal eagle cut in for that. That could tell me the specifics of this, but basically, layman's terms, you can't trademark that, which is... It's been used a lot of ways creatively, but sticking to this case, it seems like this first company, Wildflower, which is if we have to do this in identity terms, is the white-owned sex toy company that's trying, and supposedly cis-owned as well, since the other one is distinctively trans-owned. I mean, I guess if that's distinctive, this must be white and cis-owned, even though it doesn't specifically. I'm probably reading too much into an article that someone just threw together about this, actually. Anyways, there is a whole drama here, including ENBY fighting back with a GoFundMe fundraiser to secure a legal defense. And as a part of that, they are essentially arguing the same thing that I just said, that you can't trademark this. I'm not sure that they were aware going into this that other courts had already told them they couldn't trademark this. I'm not sure why they decided to fight this legal case, honestly, but I think they thought that they could just bully this other company because they were smaller and minority owned. But so as this case is going on, ENBY Store reaches out kind of to the LGBT community, and it was kind of a viral thing. There was a viral post that was spread around the LGBT community at the time to get a bunch of non-binary people to sign on to an amicus brief to say that this word is something that I find crucial in being able to identify myself, and you can't allow someone to trademark my identity. Which brings us to an email that, honestly, I didn't read until fairly recently, but I received in November of 2021 after signing on to the amicus brief, which is kind of a friend of the court. It's once again, wish I had a legal eagle cut in for this, but it's essentially when you can kind of get a group of people together to support one side or the other of the argument by putting in their own kind of opinions and their own feelings on the case. Most notable amicus brief that happened recently in the last year was the amicus brief that The Onion published in the case of the guy who impersonated a police department on Facebook and ended up arrested for it. So that's what an amicus brief is, and because of that, Remy Green, the lawyer that was handling the defense for this over at Cohen and Green PLLC, sent me an email because I was on that amicus brief to inform me that they had won the case. They also attached a decision, not the same one that I just read. I think, let me actually look at this one. How big is this? 47 pages. Holy shit. Okay. This is the pretty much the unsummarized version of the other thing I read. Okay. And I did read through that a couple days ago. That's right. Okay, cool. So the one wrinkle at that time that is mentioned in this email is that to know that the way that the court had handled it was to give Wildflower some cautions against attempting it, but technically gave them the permission to amend their complaint within 30 days if they thought that they could make a better case. Because essentially when you're reading through the case text, there is a really long portion in the discussion. There are a lot of points talking about the idea of whether or not a term such as ENBY can be described as distinctive as a matter of law. In the discussion, it is both Part B. Wait. I mean, it kind of goes into Part C as well, really, and that's pretty long. And yes, Part C being, let me get back to the top, whether the plaintiff has alleged a plausible claim for relief. And in this case, they say that while the court has declined to determine distinctiveness at this juncture, it must still determine whether the plaintiff has pleaded adequate factual allegations, not merely legal conclusions, to state a plausible claim for relief. And ultimately, if I just skip down here to the conclusion, the court, as its conclusion to this, granted the defendant's motion to dismiss. And again, it says here that, yes, that gives them the option to amend. And as far as I can tell, which is, again, kind of difficult because even searching between the date that this was published and now, there is no update on this. So I feel like it is safe to assume that since there was that either absolutely no one covered this, which kind of seems to be what's going on, but also perhaps that this was a little bit of a weird decision because, previously the courts had decided. Let's see, where was that? It was in the background. Before launching the ENBY vibrator, plaintiff tried to register ENBY mark with the United States Patent and Trademark Office. The U.S. Trademark Application Serial Number 882888201, filed February 2nd of 2019. After the examining attorney first refused to register the mark, plaintiff responded and requested that the examining attorney reconsider. The the U.S. Patent and Trademark Office then denied the application for a final time, the examining attorney again concluding that the mark was merely descriptive and thus not suitable for registration. The plaintiff then declined to file another response or an appeal with the board. As of late 2019, the U.S. Patent and Trademark Office deemed the plaintiff's application abandoned, and then they actually cite that part of that decision. So essentially, they've made this same argument without the punching bag. Kind of preemptively trying to get the trademark in there. Previously, at least 3 times to the U.S. Patent and Trade Office, and every time they've said no. So it is actually a little weird with that being this is the second paragraph of the background from the case text, which is if it's that central to the background, then I feel like that weighs really heavy on whether or not this can be distinctive, because the courts have ruled multiple times at this point that it can't be considered distinctive. But oddly enough, this court actually kind of sidesteps that entirely by just dismissing it, which I guess is a good outcome in that, this kind of ability to file an amended complaint does not seem to have been taken up. They have dropped trying to do this before, as I just read to you out of the case text. So it kind of paints a picture of them losing this battle. And again, I could be really bad at Googling, but, ENBY Trademark Lawsuit Sex Toy Store Wildflower. It feels like that, again, if that was specific enough. Wait, actually, this might be. So yeah, I guess it's possible that I'm really bad at Googling and I just can't find any sort of news story covering the conclusion of this case when kind of the announcement of this case was its own thing, but apparently that was the story. So for any of you out there who kind of caught the beginning of this and wondered how that case went, I just thought I should tell you that they emailed me as a person who had signed on to the amicus brief to tell me that they had won the case, essentially. And as far as I can tell, doing some due diligence to make sure that that case didn't get overturned shortly thereafter, it does not seem that either A, anyone ever covered this, but B, that it ever did get overturned. So, win for the ENBY community there. Rare win for the non-binary community. But even though I'm a year late on telling you about this, maybe it's a good reason for communities such as that to feel positive moving into the future, when so many other things seem to be breaking down for us. Anyways, I appreciate you for watching this, especially after I noticed that towards the very end of this video, that I've been recording this with the onboard mic on my computer, which is probably absolute garbage. And I really apologize that this video and the one before it are going to have really trash sound quality, but they were actually pretty good takes, so I guess I've got to keep them. Well, Anyways, that's all the work I feel like doing in the end of this year. It's time to go sleep it off for me now. So I guess when I wake up, I'll see you in the new year. And if you care to stick around, I've got another piece of content. I want to talk to you about some books that I am putting together and selling now. And I would really appreciate if you would give them a look. And hopefully pretty soon, although there are a lot of things that I'm doing for this project at once, and I don't know when I'm going to get any of them done, especially with my recent ankle injury. I do hope to have kind of a narrated first couple of chapters for at least one of these books to give you kind of an easier entry point to see if you want to buy it before you send some money to Amazon. A little bit of which will make it to me and help me pay for maybe a cup of coffee or two. But I appreciate it all the same because that allows me to stay independent and allows me to make a living off of my art, and I appreciate everyone who enables that. And also, speaking of people who enable my creation of things and my ability to use time this way, I want to thank my Patreon folks and anybody who's ever donated on Coffee or given me kind of leftist tech support online when I've had computer issues. I appreciate all of you so much. You have been so helpful in keeping me motivated, even through, some depression issues that I've had over the course of trying to operate a YouTube channel. But, it's been kind of a crazy ride, and I haven't stopped yet, even though I have kind of redefined my relationship to this channel several times since it started. But it feels good to get my thoughts out there, so I think I'm going to continue into the new year, and hopefully I'll have some good news to share with you about publishing and some progress made on that series, so I hope you're looking forward to it. If you are still, for whatever reason, watching the video, thank you. You have a lot of faith in me to just watch this thing to the end on faith. I like you. I like you. Good vibes. But I also want to tell you that I'm a writer and that I have recently published my third book in paperback. I just got done fully editing them. It has been a lot of work to do by myself, but if you're a Final Fantasy fan, there is at least some chance that you would like to go on a multi-story romp through a connected digital multiverse, but also kind of classic fantasy and magic experience that kind of rides the line between technology and deep fantasy lore. Expect worlds that have existed for hundreds of years and have deep historical roots. Expect characters both memorable and enchanting, and hopefully you will find these worlds and their histories and how they intersect with each other and how people come together and fight for a better world. If you find that kind of thing inspiring, check them out. I think that probably the best starting place that I would recommend is Athena's Chosen, even though chronologically it kind of exists in the middle of the series. It is the first book of its trilogy, and it was based on a tabletop game that I designed based on a book that I was writing at the time and allowed some friends to play in. So it has really interesting rapport, especially like the chitter chatter is just always very lively and interesting in that one, and it's quite a jaunty tale. So anyways, thank you for tuning in for so long. I know that longer videos like this don't usually do well on YouTube, but I appreciate you. You're a good fish there, Charlie Brown.